Will vaccination mandates remain in place in New South Wales forever? There are some industries in New South Wales where unvaccinated workers are still unable to attend work, including education, healthcare, transport workers, police, and airport workers, just to name a few. In addition, there's some individual companies who have decided to mandate COVID-19 vaccination in their business. However, a recent case in the New Zealand High Court could serve as a leading indicator that things may be about to change on our side of the ditch in the future. So today we're going to unpack some of the key details of this case, which saw the New Zealand Police and Defence Force challenging vaccination mandates in the High Court of New Zealand, with the outcome being that previously suspended unvaccinated employees being allowed to return to work. Whilst there was a religious freedom element to the case, Justice Cook, presiding on the case, ultimately stated in the decision that I do not accept a belief in an individual's bodily integrity and personal autonomy is a religious belief or practice. The ruling also addressed a couple of other findings which are quite different from those found in the New South Wales Supreme Court almost 6 months ago. Firstly, Justice Cook found that the associated pressure to surrender employment involves a limit on the right to retain that employment, which the above principles suggest can be thought of as an important right or interest recognised not only in domestic law but in the international instruments. This is of interest as the New South Wales Supreme Court found that so-called vaccination mandates for the purposes of employment were in effect not mandates. In other words, employees were not being forced to receive a vaccination, only that it was a requirement to attend work, and therefore could simply choose not to work. The New Zealand decision, however, seems to view this differently, in that a person has the right to work. Therefore, due to public health policy of mandating vaccination is directly affecting a right to work. One of the original arguments in New South Wales by both government and some businesses was that COVID vaccinations were a control measure, in part to prevent the spread or transmission of the virus. Now, whilst this might have been true with the initial Alpha variant, it appears not to be true for Omicron based on the New Zealand High Court decision. Justice Cook states, in essence, the order mandating vaccinations for police and New Zealand Defence Force staff was imposed to ensure the continuity of these public services and to promote public confidence in these services rather than to stop the spread of COVID-19. Indeed, health advice provided to the government was that further mandates were not required to restrict the spread of COVID-19. I am not satisfied that the continuity of these services is materially advanced by the order. COVID-19 clearly involves a threat to the continuity of police and New Zealand Defence Force services. That is because the Omicron variant in particular is so transmissible. But that threat exists for both vaccinated and unvaccinated staff. I am not satisfied that the order makes a material difference, including because of the expert advice before the court on the effects of vaccination on COVID-19, including the Delta and Omicron variants. So what do we take out of these statements? Our opinion is that the New Zealand High Court believes that COVID-19 vaccines may not be effective enough or at all in slowing or preventing the transmission of the Omicron variant of COVID-19. So from an employment perspective, it seems that the New Zealand High Court have taken the view that the COVID-19 vaccination becomes an individual decision which does not impact on the health of fellow employees, customers, or the general public, and rendered the mandate in these industries unlawful. So the question we're asking is, will this view translate across to New South Wales and more broadly, Australia? Now, time ultimately will be the judge of this. However, to us it seems inevitable that mandatory vaccination policies across industries and businesses are likely to come under the microscope again in 2022. And at the very least, will challenge the current mandates being further extended to require booster shots.
Does your business currently have a HR or workplace relations issue?
Are you unsure how to work through compliance issues but still achieve a good business outcome?
Why not take advantage of On Demand HR's free 30-minute online consultation with an experienced HR consultant?
At the end of the consultation, we also provide you with a strategic action plan to resolve your current issues.
To see the types of matters we can help with and to schedule your consultation, please visit ondemandhr.com.au/advice.
We look forward to delivering certainty, confidence and clarity for your business in your HR and workplace relations affairs.